Thank you all for being here. Never quite had life change on a panel 5 minutes before the panel starts. Since we're going to be focusing today on courts, legislatures, and administrative agencies, one of the opinions that we as a panel had been looking to see whether the Supreme Court was going to release it was released at about 10:25. So Loper-Bright has come out, Chevron has been overruled. So we're hoping that that will, while the panel has not had a chance to digest this opinion, we're hoping that the audience is going to have some very good questions about that.
No, you don't want to read, they will listen to us, right?
But I'm always happy and honored to serve as a moderator on either a Scalia Law School panel or a Federalist Society panel. And so for this event, I'm very fortunate to have the opportunity to do both. At this conference, we're exploring whether, as a world, we are in an area of disintegration. We're examining the shift from integration, economic, political, and legal, to a growing fragmentation in both the US and EU. Is the world de-harmonizing? And in this panel, we examine how courts, legislatures, and administrative agencies are driving or simply weathering the shift. On the American side, as I just mentioned, the U.S. Supreme Court is necessarily the focus of this inquiry, especially today, in light of the Loper-Bright decision, which overrules Chevron. And what will this case mean for legislatures and for executive agencies? That's certainly going to be something that we ponder here today and for a long time in the future. But interestingly, the evolving attitude on Chevron itself may well be emblematic of the shift that we are focusing on today. Justice Scalia famously defended the Chevron decision in a 1989 Duke Law Journal article, yet in 2017, the then White House counsel, Don McGahn, delivered a speech wherein he asserted that the greatest threat to the rule of law in our modern society is the ever-expanding regulatory state, and the most effective bulwark against that threat is a strong judiciary. And now Loper-Bright likely cements that shift. As to the EU, to what extent is such a shift playing out in the European Court of Justice? Our distinguished panel will address these issues during its discussion. I'm going to briefly introduce the panelists in the order in which they will speak, and then each will deliver their remarks. I'll give them a brief opportunity to respond to each other. I may have a few questions, but then, as I said, I really would like to have very robust audience participation. Let me start with Professor Susan Rose Ackerman. She is the Henry R. Luce Professor Emeritus of Jurisprudence at Yale University and Law School. She has done extensive work in policymaking and comparative public law. She received her PhD in economics from Yale. She will discuss the role of agency expertise in policymaking and how the U.S. model compares to that of other countries. Professor Jan Zaglinski is an assistant professor of law at the London School of Economics Law School. He studied law in Hamburg, Paris, and Oxford, and holds a PhD from the European University Institute. He focuses on EU constitutional and internal market law. Professor Zaglinski will talk about market governance from the EU side and the shifting role of the Court of Justice of the European Union. And last but not least, Professor Daniel Kelemen is the McCourt Chair at the McCourt School of Public Policy and is a professor of law at Georgetown Law. His research interests include the politics of law of the European Union, comparative politics in law, and comparative public policy. He holds a PhD from Stanford. He will focus today on how EU institutions have responded to the consensus over open economic, political, and legal integration, including the EU's retreat from enforcement and its shift from free market approaches to an active industrial policy. And now let me turn it over to the speakers in turn.
Thank you. Thank you, and thank you to organizers for inviting me to be part of this discussion. I was waiting for Loper-Bright to be decided and say maybe we'll come in a day before I have to talk, but maybe it's just as well that it is simultaneously being read by you while I am talking, because I had been particularly in reading Justice Gorsuch's dissent from a grant of cert a while ago, that he had very little sophisticated understanding of comparative administrative law, misquoting me, so I suppose that's special evidence from my point of view. But anyway, I am eager, if depressed, to be reading anticipatorily depressed to be reading the decision. Anyway, but what I would like to do today is speak about this question of executive rulemaking in different countries and how it is related to the underlying constitutional structures of these countries, that it shouldn't just be thought of as like an administrative law issue kind of sitting up there. I've written a book called Democracy and Executive Power that looks at the US, the UK, Germany, and France, and so I'd like to concentrate on those. I know the other two people on the panel probably talk particularly about the EU, but I want to focus on the constitutional structures of the individual countries. So the first point is the inevitability of policymaking going on inside the executive. I mean, anybody with a realistic view of how governments work are going to know that the statutes are not going to have covered all of the issues. So you can't just think of implementation in any realistic sense being just some mechanical carrying out of the language of the statutes, an unrealistic view of how the kind of problems that legislatures and governments face, unless you think government shouldn't do anything. And I think some people might think that. But if you think they ought to be doing things in response to modern problems, you're going to get statutes that don't have everything nailed down in the statute. And so that then raises a question of, it does raise, in fact, the democratic accountability question of how that policymaking activity that goes on in the executive can be reconciled with democratic principles, and different countries do that in different ways. And it is true that our Constitution, as you all know, doesn't say much about the administrative process. It's all differently organized government at that time. But we have an APA requiring notice and comment rulemaking for a range of policies that governments do, that has, as everybody here knows, I'm sure, key things of notice, comments, reason giving, very important, public reason giving, the comment process not being something that the agency can completely control. The agency, it has to issue a general call. I have lots of criticisms of how this actually works out in practice, as you all do, but it expresses, to me at least, some extremely important principles, and then judicial review that those processes were being followed. Now, some people will say, well, you know, other countries don't have that, and it's true, but we need to explain it and think about that a bit. Think about the UK. The UK does not have a legally required notice and comment process in general. There's individual statutes, particularly with respect to individual things like building a highway or an extra runway at Heathrow. But they don't have it for rules. What they do have is the requirement of many of the rules called statutory instruments have to go back to, not back, but go to the Parliament and the House of Lords, actually, to be voted up or down or approved, right? However, if you think about it, it's a parliamentary system. The government in the cabinet is the same majority or the same coalition as in the House of Commons. I did some interviewing of people when I spent a few months in London, and the general feeling within people in Parliament was, oh, that's the worst committee. You don't want to be on that committee that approves statutory instruments. That's just a boring committee. Nothing really happens. It just goes through. So you don't, and there is now a movement by some people in the UK to try to get parliamentary oversight to be more rigorous. But I think it's a kind of a false way to go. It's not going to work because of the organization of the parliament, the constitutional structure. Germany has also a parliamentary system. So they similarly have that same unitary feature of the legislature, of the lower house, and the government. They have in their constitution actually mentions administrative law, that rules have to specify the content, scope, and purpose of the delegation that's going on. Doesn't say anything about process, however. It just says that the statute itself has to include those requirements, and their constitutional court has approved the possibility of making policy through general rules, not to have to do everything adjudicatory. And that's consistent with the Constitution. There is a requirement for the upper house, which represents the states, the lander, to approve things that are going to apply to them. But once again, it's almost never a set of contestation, political contestation. France is an interesting, different case. France, of course, has a presidential system. People sometimes say semi-presidential. I would say actually strong presidential, which you're seeing in this current situation. Macron can call an election, and he still stays in office. Not likely, not what would happen in these other places. So you have, as opposed to a strong legislator, you have a strong president and a situation in which which regulations are being promulgated basically by the administration with some oversight by the Conseil d'Etat, which is their sort of high administrative court, but mostly that is not, sometimes there's a part of a policy aspect of it. And there have been some interesting developments in all of these places in Europe, pushing toward more public participation, more public involvement in the promulgation of executive rules. And sometimes the courts have, for example, in France, have required some of these participatory activities. So the point is, you can't say, oh, the U.S. should not have such. If you accept the idea that delegation is going to occur, right, then the question is, how do we reconcile that with democratic principles? Not to say, as I haven't read this decision yet, but some idea that delegation doesn't occur somehow, or that policy delegation, or that if it occurs, it's somehow wrong. But rather to figure out ways of thinking about how to manage participatory processes so they are not simply captured by, okay, 2, that's a good number. They are not simply captured by a small number of organized interests, and there's a lot of interesting experiments that are going on. The French have done some interesting things, but they were all, for example, they had a big citizens thing on climate. They had a recent one on end-of-life care for people, or decisions people could make at the end of life. But these were just Macron's initiatives. They were organized by him. They had no particular statutory thing. They were very interesting to study and see how they happen, but they are not a response to the idea that there needs to be something distinct from the kind of political will of the government in power that is pushing that are requiring the executive and the regulatory agencies to carry out some kind of a participatory process in the light of the need for delegation or the practical necessity for giving discretion that is related to policy to people inside the government. So we'll have to see from reading this case how much how aggressive this decision is, or how I would say how whether it's really unrealistic or not. We'll see. I was struck, one last thing, I was struck in listening to the oral argument at this, how much everybody in the court was making this distinction between law and policy, which I saw in looking at the European cases. Anybody who knows anything about government knows that law and policy can't be like kind of neatly put in different boxes. Well, that's law. We, the court, can decide on law, but that's policy. We can't. They're mushed together and have to be in a kind of thoughtful way separated and thought about. So we'll see what this decision says. But it is I at least have some concern about where we go from here, given that we've got a lot of very important legislation governing very important policies that need to be implemented in ways that balance the democratic necessary of some kind of democratic accountability at the point in which decisions are being made in the executive, not just through the legislature. So I'll be eager to see what happens. Okay, thank you.
Professor Zagonzi.
Yeah, thank you for the kind introduction, Judge Branch. Many thanks to the organizer for putting this together. We've had a great morning so far. So in the brief, we were asked to reflect on what institutions engineer legal and political integration. And very unusually, I have decided to stick to the brief. So I'll offer a few thoughts on how European market integration and governance has evolved and which actors were really key in that process. And in a nutshell, my argument will be that we've seen a shift from judicial to political decision-making, or we're seeing the European Court of Justice doing increasingly less and the European legislature doing increasingly more when it comes to governing, regulating, advancing the internal market. And to really understand why that even matters, why that's an important question to look at, we need to briefly take a look at something that I've called with a few colleagues the asymmetry thesis. Florian Becker this morning mentioned this in passing. The asymmetry thesis essentially states that the EU is good at negative integration and is bad at positive integration. We've been believing this for a good 50 years. Now, what do these two terms mean? In a nutshell, and I'm simplifying here, negative integration is this idea that we're removing local obstacles to trade, primarily through litigation. So a member state law would be challenged before a court based on EU internal market rules. It's analogous to the dormant commerce clause jurisprudence here in the US. Positive integration would be the idea that we create common rules through European legislation. Now, scholars of European integration have long believed that the former process works very efficiently, maybe too efficiently actually. The latter process does not really work. So the standard narrative we find is that we have a strong activist court that quashes tons and tons of member state acts that stand in the way of trade. And we have a really weak, ineffective European legislature that fails to leave its mark on the internal market and European integration. And this is really the view which I think is inaccurate. And I'm not saying it was always inaccurate. I think it captured quite nicely what was happening between the mid-60s and early 80s, but it has been inaccurate for several decades now. And I want to offer two pieces of evidence for my claim. The first one is that the European Court of Justice is actually, contrary to that view, doing increasingly less in the realm of market integration. This is playing out in several different ways. One are doctrinal changes. We've seen the European justices narrowing down the scope of some of the key economic rights, the four freedoms. The EU lawyers in the room will know things like KEC, de minimis jurisprudence. I won't bore you with that. It is not very exciting. What is a bit more exciting, in my view, is that we're seeing changes to the standards of scrutiny that are being applied. And in that sense, the Supreme Court decision of today is an interesting one. So this is a figure from a book I published a few years ago, which looked at how often the European Court of Justice grants member state authorities, that includes lawmakers, executive bodies, and national courts, judicial deference. And what we're seeing is that since the mid-1970s, there has been a not steady but reasonably pronounced upward trend, with the Court of Justice giving national authorities more and more discretion to settle certain things autonomously. So again, translating this into the US context, less strict scrutiny, more rational basis type review in Europe. Maybe more interestingly even, what we've seen over the past decades is that we find less litigation coming the European Court of Justice's way. So it's another figure from a recent piece I've published which looks at all free movement of goods disputes, which hold a particularly symbolic but also practical relevance in European integration. And what we're seeing here is that from the early 70s up to the mid-80s, there was this avalanche of goods cases coming the court's way. And we're kind of, in our theoretical mindset, still stuck in that period. But what's happened actually for the past 40 years, that there's fewer and fewer cases coming the court's way, which means that the court has fewer opportunities to actively shape the internal market. Now, why is all of this happening? There's probably reasons internal to the court. I think it's fair to say that the European justices are thinking that they've set out the basic principles of market integration, they've established the internal market, they can now move on to do other things, solve the rule of law crisis, do some sports regulation, but there's probably also some external reasons for that. One of them is we have better compliance. These overt forms of discrimination across Europe against foreigners have basically disappeared. There are, of course, still regulatory obstacles, but they're far less overt and open and extreme than they used to be a few decades ago. Litigants, because of that turn towards judicial deference, have lost a real incentive to bring free movement disputes. And then, of course, Dan's research plays into this too. The Commission is no longer enforcing internal market rules nearly as strongly as it has done a few decades ago. But my argument is that all of these are ostensibly side battles. The most important factor that has contributed to this is that we have more legislation. Europe's collective action problems are more and more solved through law as opposed to case law. Which brings me to part 2 of my argument. The European political process is doing more. Again, a figure from a piece of research I've done a few months ago. This shows you the total number of internal market laws, acts that are in force since the start of the European integration project until today. And these are, by the way, just the basic acts. Of course, there's a lot of kind of smaller decisions in addition to that, but this is the kind of these are the key pieces of statutory market governance. Now, what we're seeing is that in the 60s and throughout the 70s, there is really very much in line with the asymmetry thesis people, very little legislation. The Commission, the Council, the Parliament, it's not called that during those years, failed to deliver the crucial harmonizing rules that everybody was hoping for. So what happens is the court takes over. This is what we just saw now. When the thing starts to change really is after the Single European Act in the mid-80s, but then with greater force since the Treaty of Maastricht in the early mid-90s. So ever since then, we have a really steep rise in internal market legislation. I should say that the spread of this legislation is not even. We have far more laws on the free movement of goods compared with services and persons, and even within those larger categories we see variation. Very detailed high levels of harmonization on cars and chemicals, very little on military equipment and slot machines, right? So there is variation there. But overall, significant progress has been made. And the result really is that we, at this point, have a really big body of legislation that covers anything from consumer rights to environmental standards to alcohol and food regulation, which is one of my favorite examples because that, of course, used to be the key area in which we saw a strong European Court of Justice doing all of those landmark rulings that were advancing the European market integration project. So the EU legislature has not just gained in profile, it has really become the key actor calling the shots here. And just just to quickly reflect on what that shift from judicial to political decision-making means. So I think, first of all, it's a sign that the European internal market has matured. The basic fundamental principles of market integration have been established. The major trade barriers have been removed. So now the court and the EU are willing to accept that beyond this core, we leave the member states a bit more freedom to settle certain things themselves. But institutionally, of course, and this is the key argument of mine, we see judges doing less and legislators doing more. And that, to me, makes perfect sense, because in the long run, you cannot run an internal market of the size of the EU or of the US through litigation. It's way too ad hoc, way too patchy. It fails to reflect certain public interests. So it makes sense to have a more reliable, predictable, and socially responsible form of market governance. But replacing judges with legislators has also some deeper substantive consequences. And one of the interesting developments, I think, is that we've seen this contributing to higher regulatory standards in the EU. Litigation means, and I'm stating something banal, but I think it is still important, we are having challenges against certain national laws, sometimes European laws, which impose certain standards. If the litigation is successful, and it is more likely to be successful during phases of judicial activism, those laws will be struck down. Well, legislation works in a different way. It imposes new rules, which more often than not these days impose higher regulatory standards than those existing. There's many examples of that, but regulation of digital services, which was part of the first panel, I think is a good one. Here we have really quite demanding regulatory standards on online platforms, content moderation, gatekeepers. Now certain forms of AI are prohibited. So the idea here really isn't to liberalize trade, to promote commerce. It is to restrict economic activity in order to pursue certain non-economic policy goals, health, privacy, security, et cetera, et cetera. So this is a real paradigm shift. And then the final bit, and I'll stop. I think the trickier question is, has all of this made the EU's internal market more democratic? Because that's, of course, a very long debate that we've been having, at least since the 90s. Judges famously pose decisions by judgments pose the counter-majoritarian difficulty, to use Bickel's words. So one may legitimately be tempted to think, well, the more lawmakers do, the less of a difficulty we have. I think the situation is more complicated in the EU, and that's especially in the field of economic integration, because the problem with European lawmaking is that most of it is so technical in the internal market that it attracts little to no public interest, which of course is a major prerequisite for any meaningful democratic debate. Craig and his colleague Matthias have written beautifully about the regulation of lifts. This is a real success story in Europe. Regulatory standards are quite high. We have perfect harmonization. Well, you know why? Because no one cares about lifts, right? And if you contrast this to some of the more politically salient topics, then the situation looks quite different. Think about the recent protests against the European Green Deal. Farmers across Europe, but also ordinary citizens, have stood up against what they thought were too demanding regulatory standards, and have been successful at forcing the Commission into abandoning some of the more important pieces of that program. So I think we're really in a type of dilemma, because where there is democratic debate, there is often no progress on European integration. By contrast, where there is European integration, it continues to be mainly done without democratic debate. I'll stop here.
Thank you. Professor Kelemen.
All right, thank you very much. Thank you, Judge Branch, Professors Grev, Parsons, and Kochan, and to the center and all our hosts here at the Scalia Law School and George Mason. It's an honor to be here, and I'm going to make two main points, but let me just start with this. The framing that I took for my comments is this idea, as Judge Brandt referred to, that the consensus on the rules-based market integration, promoting economic openness and liberal democracy has been challenged in recent years on both sides of the Atlantic by recent political currents. So the question to us then is, in light of those challenges, how have and how should the institutions of the US and EU responded? Are the responses, the recent trends worrying? Are they welcome? So as I said, I'll make 2 points in answer to that kind of question. But first, I want to say a couple things by way of background about the EU. And I'm going to focus mostly on the EU with a few references to the US. The first thing I want to say really is just something very basic about how I see the EU and how I understand its kind of architecture. It might sound a bit obscure, but I think you'll see why it's relevant when I get to my analysis of recent events. The way I really understand the structure of the EU, it's similar to what medieval historian Joseph Strayer called a law state, which is a political system that governs primarily through judicial institutions, even while its fiscal, administrative, and coercive institutions remain highly underdeveloped or very weak. The EU relies on not only its EU-level courts, but on local courts and private litigants to harness basically existing national capacities of its member states to govern, because the EU's sort of administrative capacity on its own is very limited. And it also relies on its own central administration, the European Commission, to enforce EU law, as Professor Zaglinski was just referring to. And just to think about this, what that means concretely, the EU is this very imbalanced polity, if we think about it. It's very strong in law. There's the huge body of EU law, the acquis communautaire. Professor Zaglinski was showing us, about the rapid increase in the amount of EU legislation. I was just checking the comparisons for a transatlantic focus. The 118th Congress passed 65 laws, okay, so in the past 2 years. The EU lawmaking organs, Council, Parliament, have passed 871 legislative acts in the past 2 years, okay? So that's 13 times as many. That's my quick math. And that's with 27 countries, multiple parties, et cetera. So it says something. So the EU is big on law. It also has a strong court system. And its laws project their power internationally. There's what Professor Anu Bradford from Columbia is famously called the Brussels effect. My colleague Abe Newman is in the audience, going to speak later, has written a lot about this idea, too, of the global regulatory power of the EU. So the EU is very strong in law, but the EU has a tiny budget, right? The standard budget's like 1% of the collective GDP. If you add in Next Gen EU Recovery Fund, you maybe get another percent, but that's like 2%, so it's tiny. Tiny staff, about the number of employees of the EU is like a mid-sized city, basically. And it has zero coercive capacity. As I always like to say, no one who works for the EU can shoot you, okay? So interestingly, just by way of making comparison, the early US was a lot like this, actually, as we have Professor Rose Ackerman from Yale. Well, I assume she must have known over the years her colleague from political science, Stephen Skowronek, who famously described the 19th century US as a state of courts and parties, right? That it's the bulk of its governance was through courts and also parties. Okay, so there's parallels there. All right, so now on to what I want to talk about quickly in my few minutes I have, really, is that one big piece of this kind of architecture that I want to focus on is the role of the European Commission as the guardian of the treaties. Now, the EU has a famously or infamously complex institutional machinery. I teach students about this all the time. It's lots of fun to do with all these charts. We're not going to look at all that alphabet soup. We're going to look at one organ, in particular the European Commission, which is the main executive organ. There's the Berlaymont headquarters of the Commission. Von der Leyen lives on the 13th floor, by the way. She works very hard. And the Commission, historically, in the architecture of the EU, has two main roles. Okay? it is the engine of integration. So it is all those, when we talk about EU legislation, all those pieces of legislation originate with Commission proposals. So its job is to drive forward the agenda of integration. That's a picture of the little engine that could, if you guys remember that old story. It's this kind of small locomotive that, believes it can pull the whole series of trains up the hill. And that's what the Commission's trying to do, right? Be the engine of integration. But it's also the guardian of the treaties, charged with enforcing the treaties and EU secondary legislation. Those are the two main roles. I'm going to come back to a central conflict between those roles, which I think most EU scholars kind of overlooked for a long time. So that second role is very important, because even though there's decentralized enforcement by private actors before national courts, we heard talk of direct effect and these aspects of the EU legal system earlier that are unique, but still all that decentralized enforcement, it really relies also on a strong central enforcer, the Commission, to bring what they're called infringement actions. That's lawsuits where the Commission sues member states for violating their treaty obligations and violating common legislation. Okay? Well, something that my colleague Tommaso Pavone, sorry, got a little too close, from University of Toronto and I have written about in recent years is a trend we kind of uncovered and then explored in interviews with EU officials to kind of get at what had happened, where we sort of noticed that the number of infringements being brought by the Commission against member states, which rose steadily for decades from the 70s to around 2004, has declined precipitously since then. Right, with the number of infringements being referred to the Court of Justice down over 80% since 2004, okay? And that's the total number, same if you do it on a per member state basis, et cetera. Something clearly changed where this trend of enforcement was relaxed. Now, I'm not going to go through the whole thing. We have an article I can refer you to if you're interested in, but what we say is, and where it relates to today's topic, is that in essence, as political currents, Euroscepticism was increasing in the late 90s, early 2000s, the Commission felt itself and the European project coming under increased political pressure from Eurosceptic forces who weren't supporting deeper integration, et cetera. And in that context, the Commission, that sort of highlighted an inherent tension between these two roles of being the proposer of laws and the enforcer of laws. Because the Commission started to see, well, and it was actually when Barroso came in as president, he started to see, well, he's there excited about his legislative agenda, ideas for deepening the internal market or whatever other legislative initiatives he has. But then when he goes into meetings with the member governments, they're all mad about being sued by the Commission, which is also charged with enforcement. And there's this tension between being the proposer in the morning and the enforcer in the afternoon, right? And in essence, what Barroso decides to do and what carries on in the next 20 years is to sacrifice the role of guardian in favor of the role of engine. So in essence, saying to governments, we'll go easy on enforcement if you support our legislative agenda, essentially. So that's what happened. Now, I'll just say one more thing about that, which is, yeah, perfect. That retreat from enforcement, that relaxation, which applies to all areas of EU law. We've checked across all the different areas, and including single market law, everything. It came in the mid-2000s, accelerated in the late 2000s, just before you kind of had new governments come to power in countries like Poland and Hungary that were increasingly challenging the authority of the EU legal order. People have talked about rule of law backsliding in these countries, and certainly the previous Polish government, there was outright defiance of the supremacy of EU law, et cetera. And so this retreat from enforcement comes just at a moment when there was increasing defiance and challenge to the legal order. And some people would say you see manifest in this a kind of fraying of the internal market where more and more EU rules, this huge body of law which you're speaking about, is being violated with impunity increasingly. Okay? So my next point, I said I'd make 2 points just in closing. Let me just say one last thing about the last point, which is, I said the EU is a law state. Well, I guess this retreat for enforcement has me thinking, what is a law state that doesn't enforce the law? And I think what it is, the real danger for the EU, I don't think the EU will collapse or fall apart or anything like that, like some people say. It's just that it could become like the OECD, right? That it just kind of issues recommendations and that it's not really a law-based polity. It's more like regulations and directives are kind of recommendations of things you should maybe do if you feel like it, right? All right. But what might the EU do then if its law state and its legal robustness is fraying? Well, it looks like this is happening at the very moment when there's this move away from neoliberalism, a belief in open markets on both the right and the left, frankly, pushing against this. And instead we have on both sides of the Atlantic an embrace of industrial policy, right? We see that here with the Inflation Reduction Act and then the kind of parallel of next generation EU and Green New Deal, which is financed through that in the EU, that it's not to say the EU is abandoning the internal market, but much more of the focus and energy, as my colleague Kathleen McNamara, professor at Georgetown, has written a lot about, is a focus on a more aggressive industrial policy, subsidy schemes. And I think for those of us interested in transatlantic relations, this is important because it's a real potential source of tension, which we've seen in the past 2 years, is tension over kind of a sort of race to subsidies and economic chauvinism dividing our transatlantic community. Thanks very much.
Well, thank you to all the panelists. And before I start with some questions, do any of the panelists want to respond to any of the other remarks made by the panel? So, Professor Zaglinski, you talked about some of the reasons, the external and internal reasons why in the EU there's some shifts in the court's perspective. Let me just turn this over to the whole panel. What would you say about those both internal and external forces in the U.S. and how that might account for the changing attitudes towards Chevron deference?
I don't know. So let me get straight what the question is. So whether there's people thinking that there's too much centralized, just
We've gone from when Chevron first came out in the mid-'80s, and then from Justice Scalia's robust defense of it in '89, we have watched an evolution of people starting to pick apart Chevron, and the court itself starting to cut back on it, and now we have it overturned. Do you have any explanation? Are there internal forces that have caused that shift? Are there external forces, a combination of all?
I don't know how much the shift actually has occurred, right? I mean, there may be some individual decisions and things, but there's always the claim, well, the Supreme Court hasn't mentioned Chevron for several years, right? But to me, that may just indicate that it's just become accepted. And so it isn't, until very recently, really challenged, at least at the federal level, or at least at the level that gets into the Supreme Court. So I don't know that we can take, it's like the sort of non-barking dog problem, right? We can't necessarily take that it hasn't been litigated that much to mean that it's somehow in doubt, as opposed to the idea of some level of deference being given to the legal interpretations of agencies is the way the world is working, right? So I don't know. I haven't studied really the details of all the case law over time, but I don't know that I don't know that I accept the premise. I'd have to have some more evidence to really accept the premise with which you're stating it. So maybe the rest of you have some more.
Other panelists?
Look, so I'm obviously no expert at all on U.S. administrative or constitutional law for that matter, but just maybe from a kind of European perspective, of course, we're all aware of the Chevron doctrine. And I think what's interesting to understand about things like judicial deference is that they're both symptoms of bigger things, but that they also impact on the bigger picture. So, for example, judicial deference in the EU, at least on my reading, is really strongly driven by the degree to which the European justices trust or distrust certain institutional actors, right? So at first, in the 60s and 70s, there's a great deal of distrust, justified distrust in member states to be doing economic regulation because member states are doing a really poor job at that. So once that starts shifting, you see also the Court of Justice changing perspective, really. Then there is, of course, the kind of question of centralization versus decentralization, which we also touched on in the morning. And there again, I mean, it's not just that a kind of overturning of this precedent could have certain effects, but it's surely also underlying what is happening there, right? If you have a more centralized vision, a more court-focused vision of what a constitutional order, what an economic legal order is, this is going to be driving your decision in all likelihood. Yeah, I'll maybe leave it at that.
I won't say anything about Chevron, but since we're supposed to be making transatlantic comparisons, maybe I'll say something about administrative agencies, the European side at the EU level. So while there are these shifts happening in jurisprudence in the US on the role of agencies with this new ruling, on the EU side, there's an interesting shift that's been happening recently as well. One of what the EU, many of you may not know, the ones who don't follow, those of you who don't follow the EU so closely, but the EU has developed a whole body of EU agencies over time. So it has its own sort of fourth branch. And the role of those agencies was much more limited than my understanding of the role of US agencies by something called the Moroni Doctrine, which is an old ECJ case from the 50s that basically said you couldn't delegate any discretionary decision-making to bodies not foreseen in the treaties. So the commission, you could delegate things to because it was in the treaties, but these new agencies like the European Medicines Agency, things like that, they were based in secondary legislation, not in the treaties, so they couldn't have discretionary rulemaking. Whenever they did something like that, it had to be really approved by the commission. Anyway, my reading of recent case laws is that basically in the EU side, the court is kind of relaxed, and Professor Maloney may have something to say about this in her talk, I'm not sure, but I think the court is relaxing the Moroni Doctrine, and we're seeing these EU agencies become more like American agencies that have real discretionary regulatory decision-making, things like the agencies that were set up after the financial crisis for financial regulation, like the European Securities and Markets Authority, for instance. So things like that. So there's an evolution happening on the EU side.
Okay, let me just add something to that, because I think you're right, it's particularly those financial ones that were actually set up to have this regulatory authority, and that's pretty important in terms of something different happening, and it was challenged. So there's a ECJ decision.
A short selling case or something.
That is brought by the UK, some of the UK, right, upholding the regulatory authority of this agency and justifying it on the grounds that it has technical competence to understand the financial markets, and so therefore it's okay for them to have that authority, and we, the court, are going to defer to what, not defer exactly, but accept the legitimacy of their behavior. So that's just to add a little bit.
So that does make me wonder if the two sides are going in opposite directions, with the discretion here being constrained and the EU being expanded. I don't know, just a thought.
Although, also just to, it's not a perfect comparison, but there has been significant pushback in the EU context too against too lax standards of review, right? I mean, the whole pushback of national constitutional courts against the authority of the European Court of Justice in recent years has partly been precisely because the national judges are thinking that the European justices aren't scrutinizing decisions that the EU is making and certain institutions of the EU are making, such as the European Central Bank, rigorously enough, right? So again, this is not the proper admin law stuff, but I think it is part of that broader conversation about too lenient standards of review potentially having very unexpected backlash at the domestic and local level.
So I'm wondering whether because one thing I was seeing in the environmental area is that with respect to the Aarhus Treaty, which is a treaty, an odd treaty, it only has to do with process, and with respect to environmental things. You don't usually get treaties like that. And when it was originally promulgated, I thought, oh, that's not going to mean anything. It's just sort of about process, even though I care about process. But the European Court of Justice has actually been quite strong in requiring process at the member state level, permitting environmental groups to get standing in court and local courts. But when it affected something happening at the commission level, some Dutch NGOs, wanted to participate. No, that's the EU level. Right? So there may be a bit of a double standard here. I don't know whether you see it anywhere else, but in terms of the aggressiveness with which they'll intervene.
And Professor Zaglinski, you mentioned that there is some pushback on the EU side for sort of the self-restraint of the court. Do you see that there's any tension there that leads to any sort of destabilizing effect?
Yeah, well, I guess this fits very nicely into the last presentation because I do think that questions of law enforcement and how many laws do we have, how much discretion do we grant actors who are meant to be abiding by certain rules, they can have destabilizing effects. What we are seeing, destabilizing is a big word, of course, but what we're definitely seeing across Europe is that we have more diversity in the internal market. So there's this kind of tendency to give national actors, local actors, a little bit more wiggle room, a little bit more discretion to do certain things their own way. So national courts, much more than 30, 40 years ago, are allowed by the ECJ to decide certain, to make certain decisions on the proportionality of a national law or on the justification of a national law autonomously. There's not going to be any EU guidance on that, or only minimal guidance. Now, the question really is for me, is that a problem? Because, it can be this kind of reading of the Guardian of the Treaties no longer fulfilling their function, I think, is a strong argument in favor of that. But when we look at kind of internal market governance, I think more broadly, in a lot of these cases, I think the effect is quite minimal. So, for example, we've had court cases on Germans not being able to go to the Netherlands to smoke weed. Well, that's very unfortunate for the Germans, but this is not a big problem for the internal market, right? We have a bit of diversity. The Netherlands are going to do it this way. The Germans are going to do it that way. This is not the end of the law state. I think what adds a little bit of difficulty here is that we do have a strong, or comparatively strong, constitutional commitment in the EU to diversity, to kind of accepting, tolerating, respecting national identities. And that's, of course, a term that's become abused quite a lot these past years. But I think more than the US Constitution, the EU constitutional materials have a form of respect for this local divergence. So I think to some level, we do have to live with that.
All right, I'd like to open it up to the audience. If you have any questions, let's start. We've got microphones on either side, and I'll just go back and forth.
Thank you very much. As regards smoking weed, we don't have that problem anymore because thanks to our new left-leaning government, it's now legal in Germany as well. So that is done with. But I have two aspects I would like to highlight, and I'd be interested in your views. First of all, regarding the relationship between courts, parliaments, and agencies, I observe a development, not so young development on European level, that administrative agencies, either by the European Union or by member states on behalf of the European Union, have to be independent. And so basically cutting them off from any kind of directives or anything from the Commission or national governments. And from my probably a bit too conservative point of view that creates all sorts of problems with regards to democratic legitimacy. But that's something, even my example from the previous talk, is something that you increasingly find in administrative agencies, which creates all sorts of problems, also tying in with this Chevron problem. That's one thing. The other thing, and which relates in particular to your talk, Professor Ziglinski, is the two ways that the so important proportionality principle is used in the European Court. Proportionality is basically at the heart of every case that relates to the restriction of any type of freedom. When the European Court tests national measures restricting fundamental freedoms, they're extremely strict with regard to proportionality. No discretion, no leeway for the member state legislator whatsoever. When it comes to testing European Union legislation against fundamental rights of citizens, they are extremely generous. Then the European legislator has all types of leeways. And I personally think that's an imbalance that has to be addressed in a bit more severe way than it is right now at the moment. Thank you.
Let me talk a minute about the independent agencies. I think you're making an interesting, important point that they're independent of the national governments, but not of the EU, is the claim, at least, or at least certainly they were created in many cases in connection with the privatization of various public utilities, and the EU has been important in trying to be sure that those independent agencies are consistent with their competition interests, you know, that firms from outside of the particular member state, like France, are able to enter the market for, say, telephones or something in France. So it goes along with the goals of the European Union. And I quite take your point that it certainly is something that's sort of institutionally limiting the national government's role, which was, of course, the point of what the law was. So that's where the debate is going to go. You know, we have things called independent agencies in the United States, but none of them is reporting to the United Nations. I mean, they're all formed by statutes inside of the government, and there certainly can be arguments in favor of that kind of independence in separating what the agencies are doing from the kind of day-to-day hustle bustle inside of the rest of the executive government, as well as agencies that have a monitoring role, which we don't have very much in the United States, but things like a freedom of information agency that's exterior to the cabinet structure of government, or that's playing that kind of a role. So there's a range of, I think, interesting variations here that need to be taken seriously, not just dismissed. But it's a special problem with or issue in the EU case, because there's this other government that's doing it. We don't have the federal government, as I know it, establishing state-level agencies. Right? I mean, there's branches of them that are influencing it, but not separate. You go ahead.
Thank you. So two things, I guess, that I want to say. Are there differences in the standards of how strictly EU and member state acts are reviewed? Absolutely. I actually ran the numbers on that for the goods case law. So the survival rate for an EU act is over 90%. So essentially, an EU measure is never going to get struck down by the European Court of Justice. For member state acts, depending on the period, it's between 40 and 50%. So every other member state law gets struck down. This is a big difference. So the kind of federal polity is immune to judicial review ostensibly, whereas the kind of national parliaments are really struggling with complying with some of the standards. Now, is this justified? And I mean, the classical answer from kind of European constitutional theory, if you want to call it that way, is yes, it is. Because at the European level, we have a much better way of representing interests of all European nations and citizens, whereas at the national level we have a risk of there being a kind of narrower minority representation of those domestic interests. So therefore the Court of Justice needs to apply a stricter degree of scrutiny. It's a bit of kind of John Hart Ely type reading of EU free movement law. I do think, though, and here I'm really with you, that the point has come where we need to ask ourselves if that model is still adequate. And I think we need to ask ourselves that for two reasons. One is that the EU has matured. I've spoken about the internal market, but overall, it is a sign of a mature polity that the courts sometimes interfere with the political process. That's healthy, that's fine, it's kind of critical feedback that we need. The other thing is that, as I said about PSPP, all of this is starting to really create problems, at the member state level, because I do think that national judges, and I rarely side with the, more conservative elements at the German Constitutional Court, but I do think there is a point to be made that, maybe the ECJ isn't looking as seriously enough at the legality of EU legislation and EU decision-making as it should. And it's making a lot of people unhappy. So, I think it's a legitimate critique that it needs to be thought through. And we don't have strong kind of political safeguards of federalism in the EU otherwise, because this whole kind of Wechsler idea, of course, doesn't work in the EU as well as it does in the US. So the shift from unanimity to qualified majority voting ostensibly means that a lot of smaller nations can and do get outvoted. So I think that would also suggest that they need some form of protection, and the court could be one of the institutions delivering on that.
That's interesting.
I'll just say something very quickly so we can get another question. But Professor Becker, I don't think independence should mean a total disconnect from the democratic basis, of a country. So now in the EU context, when you talk about regulatory agencies, the basic model that the EU's developed is this kind of hub and spoke model where there'll be an EU agency established at the center, which is small, limited capacities, and then it coordinates a network of national agencies, which pre-existed it, and has them do most of the regulatory work. Now, as part of that model, they tend to impose some requirements on these agencies of, not that they all have to be exactly the same, but they have to meet certain minimal standards, and that's where you get into, I think, these things of independence. And I think the trick is, without going into great detail, how do you make sure that national agencies won't favor national firms, won't cover up inconvenient political findings, while at the same time not totally disconnecting them from the democratic basis of their government, right?
And we're going to come over here, and I'll come back to you next.
All right.
Yes, sir.
Hi, I'm Andy Smith. I'm from Bordeaux University, and I'm working as part of the Craig Parsons project on the internal markets. So I had a point, it was perhaps a bit of a throwaway conclusion by Jan Zaglinski saying that recent internal market legislation has been very restrictive. Is it really restrictive, or is it just another attempt to try and structure or restructure economic activity, make it more predictable, but in different ways, and particularly as regards the Green Deal? And again, media attention is on the farmers. They got their tractors out, they got a lot of things repealed, but they were just a part of European farming, the most vociferous part. There was a whole part of that industry that would like change, and there's a whole silent majority that would like change, but that hasn't been taken up. So I think what gets lost in these sort of debates is what about the accompanying policies and measures that could have and should have been perhaps put in place? And on that line, there are two contradictory things that are occurring. That there is this idea, as Dan Kelemen said, that the governments are looking to introduce ways of reprogramming economic activity, reprogramming agriculture to produce less intensively, reorientate farming. But at the same time, we know that implementation of EU law has been handed back to the member states in many cases, implementation of the common agricultural policy. So to go along with what Dan said about a retreat from enforcement, there's been a retreat from implementation. So these two things are contradictory. And earlier, the first panel, we talked a lot about complexity. I think complexity has always been there for government. But what is really remarkable in the case of the EU at the moment, perhaps the US as well, is that these contradictions are becoming more and more apparent. And I think that's what we need to be talking about rather than the overgeneral point of complexity.
Should I just start? Yeah, you're completely right. The story is more complex, so this was more of a kind of bullet point headline finding. But you know what, in more serious terms, and I'm glad to hear you're involved in that project, I think this is actually a question that hasn't been studied very well yet. So this would be a nice opportunity to do a big cross-country kind of national project, because there is some research on, for example, the European semester, left, right, more progressive, more economically liberal. But on EU legislation, I mean, there's a few things here and there, but it's not very solid, I think. So I think the more complex answer to your question is we, of course, have and continue to have liberalizing legislation at the EU level. So it's not as simple as that. Think about, aviation, telecoms, the big projects, energy, the big projects from the 1990s and late 80s, which are funnily now being picked up by Enrico Letta in his report. Right? So there is a liberalizing streak, I'm not denying that. But what I find quite interesting, that I think since roughly speaking the turn of the century, there has been a bit of a shift. And I see this, so the kind of indicators that I find interesting are that legislation no longer opens up possibilities for economic activity, but it restricts economic activity, and more non-economic policy goals are part of the kind of overall balance. And of course we know, Professor Galston said this, that neoliberal, paradoxically, neoliberal countries rely a lot actually on rules. So, it's a famous kind of more rules, more trade. So it's not a contradiction to have a very economic neoliberal outset and adopt more legislation. But I don't think this is what's happening currently at the EU level. Yeah, so I'll maybe leave it at that.
Anyone else have any response? No. All right. Yes, sir.
My name is István Stumpf, the professor of the Constitutional and Political Science from Hungary. I have two questions. One is, what's your opinion about the Heritage 25 project, which is declared a very clear war against the administrative state, trying to prepare the way of the next Republican president to the White House? The second is, the last decade we experienced that in Europe, the so-called agency type of activities and the different kind of Euro bureaucrats over-occupied those kind of responsibility which used to be the responsibility of the elected politicians. So that kind of administrative state, quite deep state, appeared in Europe. Is that a clear danger for the European decision-making process and democracy, or it's just a phenomenon?
Who would like to jump in first?
I mean, I don't know. To some extent, the creation of the European Union implies, or as result has been, as all of you have been speaking about, that it's making rules of one kind or another, right? And those of you who are experts on the EU have been talking about whether it's been going too far or whether it's they're focused on good things or not. So it's not as if it's something that's got a yes or no question, that just because there's a bureaucracy in the European Union which is necessary for it to function. And as somebody was pointing out, one of you was pointing out, it's not a really big bureaucracy, right? It's compared to the bureaucracies at the nation state. So you're raising the issues other people have raised, which are the kind of the justification for having the European Union in the first place, right? And people have made all kinds of good arguments for why it should be there. And once you are accepting that there's value in the EU, then there's going to be some institutional structure that's going to keep it going, and some question of how much gets done at the nation-state level and how much in the center. And you do have to realize that the budget of the EU, as somebody was saying, is maybe 1-2% of the GDP of all the member states. There's a limit to what the bureaucrats can do because there are not that many of them. And maybe there's a problem that there are not too many, so therefore they don't know enough or something, right? So it's in other words, all I would say is I see that you've been worried by some bureaucrats telling people that you care about what to do, but it isn't as simple a question as a response as, well, get rid of them, unless you really want to leave the EU. I don't mean you, but I mean that Hungary should leave the EU. That's obviously a possibility too.
Gentlemen, would one of you like to jump in?
Yeah, I'll say something. I haven't studied Project 2025 closely, but I guess I would just say this, that I think whenever a new government comes in, a new executive, they should be able to change the direction of policy within constitutional bounds, whatever country you're in. And so one can understand if, there's frustration. We've all watched Yes, Minister, right? The frustration if it seems like the permanent bureaucracy is in your way. But from what I know about that project, it sounds like the goals are much more far-reaching in a sense that, the risk would be to replace kind of technical experts in various agencies with political appointees who would let's say, go further than just the idea that you should be able to change the direction of policy, but actually remove technical expertise from government and kind of roll back the kind of independent civil service with protections that we put in place and replace it with a system where very deep down into the civil service is just political appointees. So that, I don't know. I guess my worry about that is you go back to kind of machine politics and, where when new administration comes in, they get rid of everyone, put in their people as, rewards, and then it would just go back and forth, whoever's in power, right? That sort of thing. But anyway, others can comment more on that who are U.S. experts. I guess the one other thing I would say quickly is that I think, that there's been concern expressed here already today about, the growth of administrative state, excessive judicialization. I would just say one thing. When those phenomena happen, I think it's often driven more by politicians than, it's not the overweening courts or the overweening bureaucrats. It's that politicians don't want to deal with hard choices and so delegate these things to courts and bureaucrats, and then it becomes entrenched.
We have time for one more quick question.
Oh, thank you. Okay, I'll try and make it quick. This conversation's been so interesting this morning, earlier and now, and what's coming out to me is just that a lot of what's going on here with Loper Bright, with this project, is like a distrust of government. It's like a narrative that's floating around here. And I heard somebody talk about how the kids these days don't think they're going to get their pension, and I'm wondering from you all, just from your perspective, we do need the government to solve big problems that we can't solve by ourselves. Like the air's cleaner, the water's cleaner, a lot cleaner than it was decades ago. It's like a lightning round question. What do you find compelling about agencies, and what they can solve? Is there anything there that you find compelling, or is it all just government should get out of my business? I was just curious from you all, because you're experts and scholars and people too, so wondering about that. Thanks.
I certainly don't think you should get rid of agencies, right? I mean, and I think they do a lot. It's fair game for people to be critical of how they actually behave, but and I don't. This is a long discussion, but there's reasons why we have statutes governing air pollution and water pollution and a whole bunch of other things that have to do with the fact that they are not things individuals can handle on a case-by-case basis on either governments or people on their own, right?
And since you asked the lightning round, you're asking a big philosophical question. I'll just say, none of this is new. It hasn't changed for a long time. I have picture in my house from Lorenzetti's fresco in the Palazzo Pubblico in Siena of the effects of good and bad government in the city and the country. And yeah, so that's what, 15th century. And essentially what he's showing is that when you have good government, it can produce good public goods and prosperity and many things. So but that's a kind of philosophical stance. But I think being critical of excesses and things, this is kind of the tenor here, doesn't mean you have to reject government. Yeah.
Nothing to add, right?
Well, thank you again to our hosts. Thank you to the panelists for being here today, and thank you to the audience and for some great questions. And I think we have a break before the lunch panel starts at noon.